All right, welcome back for our final panel of the day on a topic that stays interesting year to year: ransomware in Europe, best practices and pitfalls for corporates and other organizations. We have a great group of panelists. Let me start with our moderator, James Lloyd. James is a partner at Latham and Watkins. He's based in London. James is an experienced litigator, an investigations lawyer who represents clients on cybersecurity, ransomware, and privacy-related matters of all sorts. James, thanks so much for moderating. Also joined today by Robert Maddox. He's international counsel with Debevoise in London. He leads Debevoise's data strategy and security practice, and his practice focuses on cybersecurity, incident preparation and response, internal investigations, and regulatory defense. Welcome, Robert.
Very pleased to be here. Thanks, Bruce.
Next, I'm very pleased to introduce Kim Roberts. She's a partner at King & Spalding based in London. She represents global corporations and large employers on their data privacy strategy in the UK and across Europe. And Kim has particular experience with international clients headquartered outside the UK, specifically those in the US with global operations. Welcome, Kim.
Thank you, Bruce.
And finally, welcome back David Simon, a partner at Skadden. He is based in Washington, D.C. and co-head of Skadden's global cybersecurity and data privacy practice, and a member of the firm's national security group. David previously served as a Pentagon special counsel and chief cyber counsel to the U.S. Cyberspace Solarium Commission. Welcome, David. Good to see you again.
Thanks, Bruce.
All right, James, let me turn it over to you.
Thank you, Bruce. And welcome everyone to our panel on the do's and don'ts when it comes to ransomware. Ultimately, a long list of do's and don'ts isn't much use to anyone because ransomware is very fact dependent. Every investigation is different because every attack is different, and the way that the organization reacts to that attack is different. So we thought as a group that the best way to structure this discussion today is to talk about what our panelists are seeing at the moment, what's coming up time and again, what are the issues that they're grappling with, what's working, what's not, and we can talk about what organizations do to make the right decisions and get the best results in a bad situation. First of all, let's dive in, if I can, to some broad trends that folks have picked up on in the past 12 months or so. David, can I pick on you first, please?
No, happy to. Listen, I think what we've seen, particularly in Europe over the last 6 months, is an increase in the number of incidents where two things are true. One is we see more data extortion without the encryption activity. And the second thing that we see is unaffiliated threat actors. So in the first instance or early on, it's a little bit more challenging to identify a ransomware as a service group that is directly related. Often that's buried in the threat intelligence or it comes out if there's a leak site identified. And so I think that presents some challenges for clients that are thinking of their ransomware response playbook in terms of the backup story, encryption activity, and the risk calculus there. I think that the other thing that's a bit more important about that is that, and this just goes to another trend that I'm sure others will comment on, is often the data extortion story is even more complicated because you have no basis for knowing the data really came from your environment. It may be from a prior incident, maybe from a third party. It could be cobbled together based on some things that are valid and some things that are not. So that kind of brings in a bit of that AI and misinformation, disinformation dimension. So I think that puts a greater focus on data risk and security than on the sort of business continuity pieces.
Yeah, absolutely. I mean, that you mentioned the sort of the move away from almost double extortion to almost a single extortion event where you're just relying on exfiltration. What's driving that? Do you think you're seeing? How are clients responding to that encryption threat?
My quick reaction, I'm sure others have comments, is that I think companies have gotten better about their backups in the first wave of ransomware. The second is law enforcement's been more proactive. I actually think that has had a temporary effect and has actually resulted in more of a counterstrike from the ransomware groups who've gotten a bit smarter about it. We did see a pause in August, as we typically do, but I think if you were to ask incident responders right now, and I just came back from a week in France, the number of incidents and the severity is dramatically increased. And I think you see that across the board. And so folks are very busy responding. And I think that you're seeing a combination of these stories. But I think it may be a reaction to the greater focus of law enforcement to create the strong impression that these sort of responses from government, which are fairly limited, have a big impact, because it seems like they don't.
And I know, Kim, when you and I were chatting yesterday, you had mentioned you had heard recently from someone at the FBI just generally about law enforcement and ransomware. Can you give us any insights or perhaps relate what you heard from them?
Yeah, we were meeting last week in Atlanta for our annual conference, and we had a member of the FBI there. And one of the things that I think was an important fact to know was that many of the businesses that they were dealing with, and in fact, the audience participation demonstrated this at that conference, very many have FBI contacts which they would go to immediately in the event of a ransomware attack, and are working very closely and carefully with the FBI on cybersecurity programs. And I think in the States, it's a trend which we may see more of here, but a trend that you have your FBI person as your contact, and you reach out to them quickly in the event of a ransomware attack. And one of the comments that he made, which I thought was very interesting, was that relationship is increasingly important to the FBI as well. They want to understand what the nature of the threats are and to work with business, and basically made a very specific comment that the business would be seen as a victim in those circumstances and would be assisted. I just thought it was an interesting kind of holistic approach, but one that I think business is very grateful to hear.
I think on that, we've seen similar trends, but also development in the UK. When you look at the law enforcement landscape, the UK NCA has played a big role in some of the high-profile takedowns over the last couple of years. But I also think, from our interactions, at least, the NCA here in the UK is shifting towards that more US-style model. There are still some barriers to entry, I think, action fraud potentially being one of them. But wanting there is a real appetite there for threat intelligence sharing and trying to cooperate with private sector on ransomware related matters in particular, but also just more broadly. So I think one trend that we see here is greater scope for NCA engagement in particular, but also City of London Police active in this space as well, of course.
Is it fair, David, to say it's more of a must law enforcement engagement in the US, whereas I think it's somewhat more optional still in Europe and the UK? Is that fair?
It's a good question. I mean, I think that we do see in ransomware cases where you have encryption activity and a leak site involved, companies typically will want to at least have reached out to law enforcement to say they have. There was a briefing, relatively recently in the States. The FBI gathers the sort of lead outside counsel from cyber practices, and I think each of our practices were presented, and there was kind of an update. I think one of the things that was interesting from that is that the way they want to receive these communications is less automated and less through an online form and more through phone calls. That's changing. And the other thing that I think we're seeing is that, the expectations around how confident we can be when we share information with law enforcement and have them not share it with regulators, that confidence level is going down. In the UK, I think it's well known that there are MOUs in place between the FCA, the ICO, NCA, but historically that's not been the case in the United States. So I think when companies think about whether to share information with FBI, I think the challenge is it's a large organization. So when you share it with the agent that it's not always clear if it will not end up in the hands of a regulator, or a regulator asks the FBI for it. So that creates a bit more of a need for discretion around sharing.
Yeah, and is that a consideration you think about, Robert, when you're notifying particularly to NCA or other law enforcement bodies? I mean, like David says, that it's a great talking point because you want to be able to say, yes, we're cooperating with law enforcement, but you have in the back of your mind, I think, inevitably as a practitioner in Europe that ultimately you're bringing in a third party and you might be losing control of the message and potentially the investigation.
I think that's right. I would say though that in the UK in particular, I think the NCA get it, for want of a better word. Yes, there are the MOUs in place, but they're principally targeted at sort of aggregate data sharing rather than on an individualized basis, and subject, of course, to the usual caveats surrounding true national security interests and the like. I do think that clients can proceed more comfortably on the basis that if they are sharing information with the NCA, that they will not lose total control of that information in a way that I think you probably, certainly four or more years ago, you had you were more worried about that, I think, than you are now. And I think part of that is just growing maturity of the team over at the NCA on these issues and what it actually takes to collaborate meaningfully and encourage collaboration with the private sector.
And Kim, just in terms of that benefit of law enforcement engagement as a talking point, can you talk a little bit about, how that's maybe perceived by the organizations that you're advising and how they approach it? Maybe if there are differences between US-based organizations and European.
Yeah, I mean, I think it's a combination of what David and Robert were talking about a moment ago. I think in the States, it is much more common, it is much more usual. I think they see it as a definite benefit and a well-trodden path. I think that is becoming more acceptable here, certainly in the UK, and becoming more so in Europe. But I think is a little bit of a mind shift at this side of the pond, really, towards more active engagement with law enforcement. Again, to Robert's point, that it's a concern and it's a concern and a necessity for sort of increasing maturity for the agencies at this side of the pond in terms of giving assurances of businesses feeling assured that they're not going to lose control of the narrative and the information that they're passing over.
Yeah. And speaking of that mind shift, one of the other things that, we spoke about as a group, and I think we've all picked up on over the past 12 months or so as a result of working on these global breaches is again, that difference in approach between US and EU, UK organizations when it comes to getting legal advice on an incident. And I know maybe this is a slight mischaracterization, but in the US, I think with the prospect of class actions in particular and the litigation that comes off the back of ransomware incidents, organizations seem very focused on getting the benefit of counsel's advice. It seems like picking up the phone to a lawyer is often the first thing to do, whereas in Europe, organizations seem quite hesitant to engage counsel early on in a ransomware attack, perhaps even some reluctance to acknowledge it's a ransomware issue at all. And I know, David, it's something that you've come across, and I'm just interested in your thoughts as to what you think is driving that and whether you're seeing changes.
Yeah, it's a great question, and I know having spent a couple of years based in Belgium and getting my, GDPR license to kill, if you will, and spending time with clients across the continent, not just in the UK on this, I think there's changing attitudes. Certainly the ransomware story has been one where there are US touch points, where there's manufacturing in the United States with a customer base, because you can expect that if you're in the leak site and there's news picked up, then you're likely to get sued in the United States, even if there's very little basis for it. And this is a concept that now there's examples to explain to clients. I think the second thing that's really driving this is, the very productive regulation in Europe, which we'll never see in the United States for that matter. But, things like NIS2, is right on us here, DORA, these are creating notification obligations. And some of them are quite complicated. That require not just the sort of typical GDPR analysis. So counsel, I think, will be engaged much earlier on. We're seeing a lot of clients saying, can you please make sure we're ready for this? And then, of course, down the line, the Cyber Resilience Act. So if you start thinking about the supply chain story, the need for counsel earlier, and the risk of litigation, I will just add, in France, in the UK, in Northern Europe, we are seeing a heightened focus on collective action type activities, so litigation risk. And then I think that the sort of DSAR and similar types of requests you do see after an incident are the kinds of things that I think are driving a higher focus on counsel. But I think the reason they hire us and you all, I'm sure, is not just because we can wrap it in privilege, it's because we understand how to integrate all of it.
Yeah, absolutely. And Robert, I know, David mentioned there this rash of new cybersecurity legislation like NIS2, DORA, the Cyber Resiliency Act. Are they going to be the game changers? I mean, David seems to suggest that they are, but I'm wondering if it's more just, inevitably there's the standard from a cybersecurity perspective, and this seems to be just an expansion of the scope. Like, how do you see it playing out?
Yes, I mean, good question. I think if you look at DORA, and on the technical controls side, it codifies a lot of what many, if not most, large financial services firms are already doing. They just might not have tied it in a neat bow that's regulator facing. But I think on the incident reporting side, it will represent a sea change, and in part that's because under various member state regimes, the reporting frameworks for financial services firms on cyber-related matters have differed quite significantly, and the regulators' expectations have differed quite significantly, to put it mildly. And DORA, I think, brings that a coalescence to the fore, and with it, frankly, quite a lot of challenges. When you first look at the reporting thresholds, you look at it and you think, okay, these are quite high, and then you scratch down a little bit beneath the surface, and you realise with some of the definitions there, you could be reporting a pretty large number of incidents if you are a financial services firm of any significant scale in the EU. And I think, being candid, I think the EU's made a couple missteps here. I think it's pitched some of these thresholds a little bit too low, and I think regulators may, in the early stages, get more incident reports than they actually want if people are complying with the letter of the law, so to speak. There.
Yeah, I was going to. One of my follow-up questions was going to be about the resourcing. Frankly, inevitably, regulators, or particularly the privacy regulators, are already swamped by notifications, and I wondered, Kim, what your reaction was in terms of, yes, more notifications, more regulation, but do they have the money and the resources and the time to deal with them?
Yeah, I mean, the increased complexity of reading across all of this legislation, from the point of view of understanding where obligations lie, is can take a good amount of bedding in. I think that's true to say, and there are obviously periods under the various legislation which is coming into force, NIS2 and DORA, which allow for that, for becoming more comfortable with that. I think possibly similar to GDPR, obviously a huge amount of concern and alignment within businesses at the beginning of when GDPR came into effect. And that took a good amount of getting used to and resourcing internally within businesses. And that's now become, very much more commonplace that there is a privacy officer, there's a data protection officer, et cetera, et cetera. So I guess it's increased workload for those individuals. Actually, curiously, I heard it was probably quite anecdotal, but a concern that investment in privacy officers within organisations was decreasing, and that was quite simply because there is obviously significant focus on cybersecurity controls, and increased legislation in this space. So that if you were to choose one, you'd probably go down the line of thinking that you needed somebody to help on the cybersecurity front more than you did on the privacy side. So a combination, I guess, is obviously complexity. There's a bit of a run-in time, which will, in the same way as it was under GDPR, be essential for businesses to come up to speed. But the workload is increasing, the complexity increases, and I think it's going to take a bit of time to get used to all of that for sure.
All right. Really interesting discussion about maybe those trends and the scope, and I figured now we could just look in a bit more detail at some aspects of ransomware, and something that is always fascinating and generates a lot of discussion is engaging with the threat actor and ransom payments, sanctions. Always contentious and always brings lots of different views, ethical, moral included. And as the panel's already discussed, we've seen variations in extortion tactics. So, Robert, maybe can you just give us perhaps a quick overview on ransomware negotiations generally, and perhaps just touch on the use of specialist negotiators to conduct those negotiations? Just give us a sense as to what that looks like, and then we can talk about some of what we're seeing.
Sure, happy to. I cannot think of any of our clients who have negotiated directly themselves with the threat actors. I think the clear position in the market is you're going to be working with one of a relatively small but still growing number of firms that provide specialist ransom negotiation services. So they will be your conduit to communicating with the threat actor. But I think more than that, the best in the business there also bring with them significant threat intelligence, and tying into that sort of law enforcement angle that we touched on earlier, and bringing the two together. We've seen instances where some of the ransom negotiators have, frankly, better threat intelligence regarding a particular group than US law enforcement or UK law enforcement do, because they've seen more of it, or vice versa. So I think actually those providers are not only an essential part of the actual negotiation process, but also an essential part of the response. And if you are looking to better understand who you're dealing with, they're often a good way to do that.
Yeah, absolutely. And David, I know from our discussion yesterday, you've been thinking a lot about the sanctions implications, particularly obviously with Lockbit earlier this year, but other groups besides. I'd be interested in your thoughts generally around sanctions and how that's playing out.
Sure. And I mean, just to add to what Robert said and to answer your question, I mean, obviously companies have to evaluate the strategic objectives of engaging. If you talk to a negotiator, they're going to say you should communicate with the threat actor, but careful what you wish for. They may make bold claims that they'll then leak, and it's hard for you to cabin those. So I think it's important to assess what the claims are. And I'll just add one threat and then answer. I mean, we're seeing a growing number of these extortion situations where the threat actor is claiming that there's been a reduction in the stock price of the company. And that means the SEC is going to investigate, even if there's not an actual reduction. So these are hard things to manage, some of the different dimensions. I think one of the things in the Lockbit context that we have seen is that with the greater transatlantic collaboration with law enforcement on the takedown efforts, there's also been a greater focus on sanctions. And if you look carefully at the delta between what the US regulator in this context, OFAC, and then the UK equivalent OFSI have said, if you parse it carefully, I think obviously this is not a consensus view for all, I'm sure, lawyers, but at least our position is that the OFSI, public, press release around Lockbit would make it challenging to communicate with Lockbit without a license. And that's not the view of a lot of organizations. We have a substantial number of former OFAC folks here in our practice. And so that just changes the calculus. Do I need a license just to communicate? What's your risk appetite? I think also you see that in the way that some of the counter extortion firms operate. And if you notice a difference in their approach, one's more risk averse than the other, that should also temper your thinking. The other thing is to think about, we do see a greater number of stories where the threat actor is not looking to get paid in cryptocurrency. And so that introduces an entirely new dimension, or well-known, but in this context, less appreciated dimension of AML and other financial regulatory disclosure obligations, which many organizations are not ready for. We recently had one where the payment was to be made on the subcontinent, and to an actual bank that is well known. So I think these are some of the questions that I think companies need to think more about, not just from a sanctions perspective, but also in terms of the broader financial regulatory mix.
I was just going to say one comment on the sanctions. I think what we still see though is sanctions are playing catch up, and often by the time groups or individuals associated with the groups have been made subject to sanctions, you're sometimes on the tail end of that group as a prolific threat actor. That's certainly what's happened sometimes in the past. Whether we see sanctions authorities getting out ahead a little bit more, maybe, but at the moment I do sometimes feel that they're still playing catch up and a little bit behind the curve.
I'll also just say, because of the sanctions focus going back several years, and the well-established set of incident responders who are doing these payments or involved in negotiations that lead to payments, I think we should not have the illusion that government agencies are not paying close attention to these. So I think that when we do think with clients and we about what are the costs and benefits of not just notifying law enforcement but being pretty transparent, that's something that should be considered, because certainly the authorities of certain governments to get access to information from companies that do investigation work, that do payments, that do other things, is maybe much broader than a board may appreciate when they're thinking about how much discretion they have in their decision one way or the other. And that has animated a lot of these discussions. In the US, obviously, we're going to have a much more rapid notification obligation for critical infrastructure companies within 72 hours coming into the new set of laws that are like NIS2. And I think that will also change the way that boards think about engagement and transparency.
Yeah, I think transparency is an excellent point. Particularly, I would say that's always for me one of the biggest trends over the past 12 months. It just seems much more open, much more willing to share, and frankly, it makes me think as well about ransomware generally as a communications issue, because fundamentally, folks tend to know when you have suffered a breach, right? Like, either systems are down, customers are generally aware, employees are invariably aware, and long gone are these days when organizations would sort of ambiguously refer to an IT outage. Frankly, that just gets you into worse trouble these days. Just to change tacks a little bit, I'm interested in your thoughts about those communications, and maybe starting with internal communications. So thinking about employees in particular in those early days when they can see what's going on, they understand it's a ransomware attack, and generally people will go straight to the thought that, yeah, my data is impacted, and you start getting those inbound questions.
Yeah, it's becoming an increasing challenge, as you say. I think striking a balance in the same way as you do when you're outward facing, when you're inward facing with your employees is the best way forward. Obviously, striking that balance between how much you inform them about and how much you disclose before the facts of the investigation are known. And certainly you can cause very significantly unsettled workforce if you over disclose, and of course, because the data that you hold about employees is likely to be significant and potentially sensitive, it can create a lot of concern within the workforce. The issue, of course, is the confidentiality of the disclosure to the workforce, and making sure that the alignment with the internal comms is the same as the external comms. That may not always be enough. I think one way in which some workforces are assisted is in the EU and in the UK as well. There may be additional obligations to disclose information to employee representatives, so in works councils or perhaps trade union representatives. Their workforce agreements may require disclosure of information to the works council, for example, which is materially important to the business. And I think, in some ways this is a benefit because it assists with the dissemination of information in a way which is orderly via hopefully skilled communicators, representatives who own potentially additional obligations to confidentiality because of their role as representatives. So you perhaps have a channel there which assists communication within the workforce, but it certainly is a balance, and one that is very difficult to overcome. And going back to the point you made right at the beginning, James, these are guidelines and tips, and obviously ransomware attacks and any cybersecurity attacks are very, very fact specific, and that will lead the nature and the content of the communications in any event. I think one of the things that you just to bear in mind is, over disclosing to employees does create real and material liabilities, certainly under GDPR and potentially elsewhere. And if you don't get the communications to be sufficient or meaningful enough, that can contribute to the value of a claim, particularly when an individual may be claiming non-material losses as a result of a data breach.
Just to add to what Kim said, having spent not just time in Europe, but working so many incidents where the US headquarters or Asia-based headquarters may not appreciate how much independence and autonomy European data protection authorities and data protection officers have. And so in an incident where there's a view that they're speaking with one voice to employees or externally, it may be the case that a DPO in Italy, for example, takes the view that they need to report under GDPR immediately. And I think we'll start to see that under NIS2. And so I think that really thinking through that plan with an understanding of the regional approach is important. One example, where, manufacturing was down in Europe for a client that was not based there, we had employees of a client that went ahead and notified authorities seeking basically COVID-like, subsidies for not being able to go into work and therefore claiming this was a cataclysmic nightmare of an incident at a time when the company was not deciding to disclose it to anyone else, and certainly not characterizing it as a nightmare. So I think that the what's in the best interest of employees and what's said in the Works Council can often be, for incentive reasons, the opposite of what you're saying in some other context. So that is something that companies, I think, really underestimate. It's a great point, Kim.
I think especially given the increasing scope for individual liability, right, for some of those who are on the ground, actually responsible persons for the entity sitting here in Europe. And I think they sometimes do feel that they need to go out on a limb. And how do you manage that? I think the other thing that we have seen in the ransomware context is, what happens if you don't pay and the data is leaked? And what do your employees do then? And how do you manage that scenario? And one of the less common, but I think interesting examples of a challenge there is, if you've got a highly technical workforce and you have to be open with them and tell them that data has been leaked, that includes, potentially their data. We've actually seen instances where companies have then identified that people in their workforce are going out and trying to get it. They're wanting to download it from the shame site. And actually the need for strong communication surrounding, yes, it's been leaked. What are we doing about that to try and avoid people taking matters into their own hands? And that's an extreme example. I wouldn't want to suggest that happens all the time. Most people wouldn't know how to do it, but in certain organizations, that's a risk that you've got to think about.
Yeah, I'm smiling ruefully the whole time, because I think we've all come across instances that touch on each aspect that you've talked about, but trying to herd cats. So you've got, as David mentioned, DPOs over here kind of going off and making notifications. And, as Kim is saying, you've got concerns from the employees, and Robert's saying, where somebody's downloading data from the dark web, trying to keep a cap on that. I'm not sure I have a particularly great answer to what the solution is, but maybe, frankly, it sounds like one of the takeaways is related to transparency, and just getting ahead of it and thinking through, to David's point about NIS2, and anticipating where the issues are going to arise. But I don't know how much you can really do in advance. I mean, ultimately, are you just buffeted by the tides, or do you think that really you have control in this situation?
I think there's the illusion of control, but there's two things that make it very different to practice in this space in Europe. One is, in some jurisdictions, particularly France, the role of the prosecutor is so prominent. The role of the police versus the way the FBI operates is very different. And I think also there's going to be more cross-sector, related collaboration, because if because of DORA, there's that much more reporting, or because of the way NIS2 operates, there's a greater understanding in the eyes of, government agencies that aren't typically regulating. They're going to be communicating out. So you'll have multiple companies in the same area, may not be the same sector, knowing about the same incident. And the role of government will just be a bit more pronounced. In the US, we have ISACs that do this sort of thing to some extent, but in Europe, that's a little bit less common. I think it just means that there'll be a bit more of a broader aperture, a bit more transparency. And I think it'll be a real question if you can establish privilege in a situation like that. But I think that's what we should expect. And I think that's what we're seeing.
I did want to just touch on a good question from an audience member for the group. Please do chip in. The question is, what are the biggest concerns around regulations with GDPR and ransomware as a SaaS provider, especially when customers could be using their customer communities that aren't moderated for links or images that contain malware, watering hole links and the like? Any thoughts on that? I mean, I think in some ways it also touches on one thing we were talking about yesterday, I think with you, David, about scattered spider and litigation that might arise from compromised third-party vendors, but just generally how you can manage that. Any thoughts?
I mean, happy to jump in with one thought, which is, I think on the regulatory side, what we've seen is increased focus on data processes, technical and organizational measures. And if you looked at it back in 2018, 2019, even 2020, 2021 even, you didn't see penalties against data processors, the service providers, for data security failings, which gave rise to cyber incidents. Everything was falling at the door of the controller, and I think that's a shift that we've seen, and I think will just accelerate. So I think someone that's in that data processing in the data processor camp is now going to have to think much more carefully about their potential liability to regulators. And then, of course, you've got the litigation risk side of things as well, like you say.
And I think that's right. I mean, obviously both DORA and NIS2 have supply chain components to them, and they regulate tech in a way that US tech companies have never been regulated before. So that will create that for processors, that dimension. I think it will also create a question around whether a processor designation makes sense. Are they really processors? Are they joint controllers? And how is that set up? I think the other key thing is that there is a greater focus on just concentration risk, and I think that will also affect whether a processor's role is as prominent as they want it to be. And then, of course, in the United States, there's going to be a greater focus on litigation. I mean, that's where the greatest claims are being brought, and then they're shifted from one to the other. So you see not just class action litigation, but if you look at the Delta Airlines litigation, focused, again, this is not a cyber incident apparently, but litigation against CrowdStrike, or the Accenture litigation against Marriott. These are models we expect to see more of.
Right. Maybe let's touch on some of the successes, and in particular in relation to recovery, maybe partial successes, but for organizations that have suffered an attack, seen malware deployment, perhaps an encryption. What are we seeing recently in terms of their ability to recover? I know, again, David, sorry to call on you, but your experience helping organizations from recover from ransomware attacks, I think you've started to see maybe successful trends.
I mean, I'd say that if you think about the good, the bad, and the ugly in recovery, I think the best case scenario is where an organization has thought about how they can either spin up from an on-prem situation to a cloud-based solution right away. If they have thought through how they could accomplish that, that can make the recovery story from a customer employee perspective seem almost seamless, like a network upgrade. I've seen that happen more times than I would have expected. I think where it's more challenging is if you haven't thought about how much you depend on third and fourth parties. So the Change Healthcare incident in the United States, a company no one had ever heard of really, but as part of United Health, which touches on 75% of the US healthcare system, many organizations have probably not thought, what if some subsidiary of a healthcare company I don't think about went down? And as a result, for many months, many healthcare organizations could not function. So I think it's thinking about recovery, not just in terms of how you would recover, but how you would manage to change if you have too much concentration risk. This is something that is really, really challenging. I think something like $4 or $5 billion in loss in the first couple months of that incident across in the United States. And I think we're seeing more of that. So I think that's one of the key stories.
Yeah. And Robert, what are you seeing in terms of companies being prepared for the recovery exercise? So thinking about seeing bandwidth.
I think the best prepared organizations have recognized that recovery is a unique skill set, and the need to have ideally lined up who you're going to rely on for your surge capacity for a large scale recovery effort. And it's typically not the same people that are going to be doing your technical forensic investigation and containment efforts. It's just a different skill set. A bit like InfoSec is not IT. And I think we're reaching that sort of 2.0 of maturity of response. People were very focused on the investigations and containment. Who are the right people for that? And now, with the increased prevalence of disruptive attacks like ransomware, I think people have cottoned on to, let's make sure we've got the right people for the back end as well to ensure that we get back on our feet as soon as possible.
Kim, one of the things that I think we see quite a bit is in relation to encryption, disruptions to payroll, and employees not getting paid, frankly, or at least perhaps not for a little while, and then pivoting to perhaps alternative solutions. Do you see much of that? And can you maybe talk to some of the challenges and what companies might be thinking about to minimize their liability?
Yeah, I mean, it has come up from time to time. It's the kind of the significant risk for an organisation that they can't pay their employees. In terms of backups, really very difficult indeed. I think I've seen organisations struggle with this quite significantly, from just not being able to instruct payroll to having to cobble together some sort of manual payroll in order to overcome the sort of initial hurdle of being in that situation at the time of an attack. I don't have any fantastic solution stories for that, but only to say that it is crippling, and it can be, clearly it just adds to that heightened concern within the workforce, and if it's a large organisation, that can be really damaging.
Definitely. One of the, relatedly to employees, one of the things I think we touched on this the other day, Kim, but one of the things that we have struggled with on a couple of breaches this year is in relation to notifications in respect of employees and lead supervisory authorities, particularly where you have highly sort of siloed organizations. Maybe they've got a headquarter, outside of Europe, but they've got various different organizations within, and the extent to which you can actually rely on the lead supervisory one-stop shop model or not. Is that something you've come across?
Yes, frequently actually. So this, very often happens where there is a reporting requirement in the EU, and the lead supervisory authority just hasn't been identified. That's just, that's the basic threshold problem, that the organisation hasn't done the work to establish which is the lead supervisory authority to report to. And then, as you say, there's kind of another level question, which is, even though they may have a nexus to one or other European member states, they may be a significantly diversified business across the EU in such a way that it might not make sense to report to the regulator in the nominated member state, depending on the nature of the breach and what data has been compromised. So that's another issue. But it's a significant word of warning to have this thought through in advance, because not knowing who to report to at the point at which you're making a decision to report is a significant delay in the process. Trying to patch a decision to report to a lead supervisory authority in the heat of the moment to give some credibility to that decision is a very difficult exercise. And we've certainly seen clients also in the situation where they've had to go for one or other lead supervisory authority because they didn't want to run the risk of not reporting at all, and also that is balanced against the concern about reporting to multiple regulators. So they've gone for one or the other, and then sort of 2 months down the line, having heard from the regulator in response to the report, the regulator simply said this report shouldn't have come to us. So then being left in a situation of not knowing whether you've actually complied, because you may not have got that initial reporting piece to the right regulator. So yeah, I think it's one of those huge words of warning in the process for preparation for reporting breaches.
I think we're almost at time, aren't we? I think we're just a couple of minutes away. Maybe we should just turn to some of the best practices and leave folks with something of a tip to go away with. One key piece of advice, perhaps, for defending against ransomware attacks. I appreciate we've covered a lot of it already, but perhaps if there's one thing that you can distill from our discussion, what would it be? Robert?
Sure. I think don't forget the human side of cyber. It sounds a little bit cliche, but communication's key. Your response effort is dictated by the people you've got involved, and ensuring that there are strong lines of communication. I think actually that can make the difference between a good response and an excellent response, if you've got people who know and trust each other to handle these incidents in an effective way.
David, any thoughts?
I think that, of course, you want to have the right team. Cyber's a team sport. I think what we see is that for organizations, they need an incident commander, but if they're a sophisticated organization, I think they've got an internal leader. It should be clear who that is, and they're adequately empowered. And if there's a story where they need real recovery help, they're going to have to chop that over to outside supporters, advisors. And so to be clear as to when that happens, who has authority, so you don't have not just two cooks in the kitchen, but you can't get your Michelin star if you've got 5 people who think they're running the kitchen. it's just going to be a disaster. So I think that's one of the things that we see clients really needing to figure out, especially if there's a negotiation or a ransom story recovery.
For me, I'd just say a bit of a combination of what Robert and David had just mentioned, but it's practice, say running tabletop exercises within the organisation, using real life scenarios, as in realistic scenarios for your breach response, thinking about who are the stakeholders involved, not trying to get everybody in a room for 12 hours straight, but using the skilled people at the right point in the narrative, bringing in the C-suite at the point at which key decisions need to be made at the executive level. But yeah, basically practice, because these are skills, and an organised response, which is practice, is going to be more effective.
Wonderful. Well, I know there's a heck of a lot more we could touch on, because we did on our pre-calls, but thank you from me anyway to Kim, David, and Robert, and Bruce. That's done.
Any last words from you, James, or have we covered?
One tip. I'm not sure I can better that. I like the theme of transparency that came through. Actually, I do think that's where it's moving towards. I think gone are the days where you can just take for granted that this is an in-house issue, and something to be dealt with by the IT department and sort of squirreled away. Unfortunately, I think the world kind of knows about it now, and the more transparent and open you are with it, within limits, of course. I acknowledge there's always limits, but probably the better results you'll get.
Well, Robert, Kim, David, thank you so much. And James, thank you for moderating. Great job. That is our last panel for the day. I'd like to thank the 10 world-class law firms that were represented here today as participants and supporters of the event. And thank you all for being with us and joining us for this virtual event. I hope we will see you again soon. Thank you.